to see where the miscommunication was,
Because it shouldn't be that.
because she doesn't believe it should be that expensive either.
Yeah, I
She said
just,
she'll call them and get back to me.
because we have other people that we've done this with before, and I never heard of the 70. Court calls the case, People versus Chloe Whitsett.
I'm Kia Hickman, standing in for the attorney of record, Caitlin Crapo, PA 6783.
All right. Okay, and what are we doing today?
So I spoke with Caitlin and he emailed me the compliance for the bond. So she said that we would be going over
Pardon?
the compliance for the bond, the non-compliance.
Are you here on this one or no?
Nope, I'm not.
Okay. The compliance for the bond.
Yeah, and then she said to set a new date. I'm just standing in for Caitlin. So
No, I hear you, but I'm just trying to figure out. So I can set a new date. I guess I'm trying to figure out the first thing that you said to me about compliance with the bond.
yeah, she brought up to myself and Ms. Chloe that she was emailed a report from bond compliance for pretrial release.
The progress report?
Yes.
Oh, okay. All right. And I guess, hey, let's deal with that then. Do you have a medical marijuana card?
Yes, sir.
Let's see. Has provided a copy of medical marijuana card, issue date of the 20. All right, so let me ask you this, ma'am. They got you to test it on site in Detroit, right?
I wasn't able to.
Because you couldn't afford to do it.
Yes, sir.
Okay.
They wanted $70 and I just,
Oh,
I didn't have it.
no, I got you. Is that the only place there that, I mean, because our tests are what? Well,
Yes.
She currently lives
she
in,
lives in the Detroit area. And so they had her go to onsite, but the test is 70. So she was having issues with transportation. So, but at that, she could Uber,
here.
take the darn test and get back for what they're trying to charge her. Right? It's crazy. All right, let me.
I mean, I'm not sure if you want me to.
Well, it has to be an approved site.
Right.
That's the problem, but they can't take folks and have us charge 12 and say, okay, yeah, you want to test, and then charge 70. I mean,
We agree.
and she goes there and then she can't do it. And it looks like she's in violation, but it really is just she didn't have the $70. It's one thing trying to scrape up 12 if you ain't got it, but trying to scrape up 70. We're gonna try to sort that for you, see if we can find you a place, okay? Ms. Whitsett.
Yes, sir.
Ms. Whitsett, how you doing?
Again, I'm here.
Okay, but no, hold on. Because you remember the first time we met. You remember that day?
It's famous.
It is?
Yes, sir. I remember.
Because you were having a day.
My life.
And then you then you wanted to spread it to everybody. And everybody didn't want to have all that.
And I apologize, Your Honor. I truly do.
The good thing is I could tell that you were having you were just having a bad time and just needed to do whatever. Okay. And that's probably the only reason you didn't go back there. I could, I guess, tell if you calm down, got stuff situated, you'd be okay.
Well, I thank you, Your Honor, for having such excellent discretion with people because I needed your help.
Yeah, and I remember when I tried to say something to you, and she was by the door. She turned around, just not by the door there, by the gateway to the well. And you just turned around and just snapped at me. And I'm like, okay.
Oh, my medicine.
What do you say?
I don't think I was on my medicine either. But I do apologize.
I could tell something was wrong. Then you came back the next time. You were a little better. You weren't quite like you are today. But I said, she's working it.
Yeah. Ms. Wild is going to contact on-site to verify information regarding that.
Very well.
Regarding the price of the testing in Detroit, to see where the miscommunication was,
Because it shouldn't be that.
because she doesn't believe it should be that expensive either.
Yeah, I
She said
just,
she'll call them and get back to me.
because we have other people that we've done this with before, and I never heard of the 70. So what kind of tests were they trying to give you? I mean, that's the other thing.
Well, they said all panels. So I don't know what that means.
That's everything.
Right. But I guess, and then it was in Troy. Yes, it was out, not that far from where I'm at, because I'm like closer to 8 Mile, but it was out in
Oh,
Troy.
okay.
And there was quite a bit of,
Where was it?
I have to look at the address. I have to look at my
Okay, let's do this then. How much time out how much the adjournment, how far out?
She let me know that she's available in July. So
She's man.
I have her schedule.
All
Every
right.
court is like, I'll let her know. But every district court is different. So I don't want to say a date and, it's not proper. But
Every district court is different.
they are.
I know, they really are. But we're the only ones that do it right.
Okay. So she told me July. I'm thinking July 11th. It's clear for her.
Yeah, okay, it is.
Yeah.
That's what I'll do then. That's a Thursday, so. So I'll adjourn your probable cause conference to July 11th, 2024. I set it at 9, but she'll get a time block for the block assignment.
Okay.
Okay. And then what did she want her to do? She's gonna call and verify and get back to us now, or
Yeah,
does
just-
she want her to?
I did come here this week because I just had to drop yesterday, the day before yesterday. So I was able to get here this week and drop.
Gotcha.
So
Okay.
next week, I don't know what, I guess depending on what day.
Right.
I
I can share whatever information Wild shares with me with council.
A line
All right.
call every day. and-
So here's what we'll do. I'll just, at this point, I'll just continue your bond. I'm not gonna, I got why that happened. We're gonna get information from community corrections. She's gonna double check into the price and everything like that. And rather than have you guys wait, unless you want to wait, we will then email what we get to council.
Okay.
So that way you know, and then they'll communicate it.
Perfect.
That'll work.
Yes, sir.
All right, fantastic.
All right.
Thank you so much, Your Honor.
Bond continue.
Thank you.
Mr. Westside, you made my day. I know, shocking. You wouldn't have thought that 3 or 4 times ago, but you made my day because you came in here finally and you're smiling. And
Well,
that makes me happy to see, because that means
I'm glad I-
through whatever you were going through, you're enjoying life a little bit more. And that's what it's all about. All right,
Thank
you take care.
You too, sir. Have a good one.
Nice meeting you, Judge.
Yes. Court calls the case, People versus Dolores Strickland.
Good afternoon, Your Honor. Rachel, Assistant Prosecuting Attorney. and the people.
Assistant Public Defender Hannah Apple appearing on behalf of Ms. Strickland. Ms. Strickland, will you please state your name for the record?
Dolores Strickland.
Your Honor, we are here today for a bond violation hearing that was set, as well as a probable cause conference. I think the reason that was initially set is we didn't have an opportunity to review those calls with our client. At this time, Ms. Strickland does wish to admit to the violation of contacting the complaining witness in this case. And then we would ask that the matters be set for preliminary examination.
Your Honor, for the record, I did have some communication with Ms. Apple via email. I didn't make an official offer, but suggested that it's something we could keep negotiating. What I would not have included in that offer would be any reduction of the child abuse third degree. I also would have wanted restitution on all counts, even any counts we would dismiss as part of that plea agreement. The purpose of which was, it is very important to us in making offers, especially things like this, that don't go through having to testify. But again, that was not an official offer. My understanding is that Strickland does want all matters set for exam, so we'll see it accordingly.
All right. People have I'm presuming that you have all the discovery.
Yes, to our knowledge, yes, we have all the discovery.
You will be ready on the 25th?
With that, We could set out an additional week, I'd appreciate it.
Any objection for the defense?
Do you want it on the 25th? Are you okay waiting a week?
I mean, the ultimate issue is that they get started on the 25th and then get an adjournment and probably go out further.
Your Honor, Ms. Strickland indicates she'd asked that it be set for the 25th. These cases have been pending some time. She's been in custody for quite some time. So we would ask that they set at the earliest date available to the court.
Thank you.
Okay, well, here's what I'm gonna do then, you know. June 25th, 2024, 9 a.m. That's in person. I'm gonna put it before Judge Washington, and here's the reason that I'm doing it. If people don't have all of their witnesses, particularly on some of these cases, you could certainly start the exam with Judge Washington on the 25th. Judge Washington, who would then have to take it, is up that following week on the 2nd. So certainly, and I'm not promising anything for her, but at least it gives you some leeway to get you to your week without having to do it the other way.
Your Honor, I think I'm and I'm not completely confident, but I believe Mr. Strickland may be in custody on at least another matter.
You are?
I don't- It's just those three files
Just the three
that
cases.
are up, to my knowledge. I didn't go looking though. So,
Yeah, that's it, Your Honor. That's-
Okay,
okay.
all right. Well, we'll set it for the 25th before Judge Washington.
Thank you.
Thank you. Does the recall the case, people versus Jadon Marita.
Mr. Sinatra, senior assistant.
And good morning, Your Honor. Good morning to your staff. May it please this most honorable court. Edward Martell, P 85051, on behalf of Jaden Merida, who joins us at the podium. Mr. Merida, please state your full name for the record.
Jaden Meredith.
Judge, if I may.
Go ahead.
Judge, first and foremost, let me apologize to this honorable court, certainly for my tardiness and or absence earlier. I was caught into a Third Circuit capital case, and so certainly my humblest apologies. As it relates to this particular case, Judge, we're respectfully demanding an in-person examination on both matters. I would humbly ask for separate dates as they're not related, and I would humbly ask for after July 1st, as me and myself and Mr. Nasser have an upcoming federal matter in Bay City.
Are people going to have any issue with July dates?
Your Honor, I've not had any conversation with counsel, but if that's what he wants, and that's fine with me. We will always have somebody available for a preliminary examination. July dates will accommodate that.
Is all discovery complete, counsel?
It is, Judge.
In case 24 FB 21208, preliminary examination in person, are these related? Why would you need separate dates?
Judge, they're absolutely unrelated. One is allegation of
So you
within
don't
the
need,
jail.
you don't need separate dates.
Judge, I will leave it to this fine court's discretion. If Your Honor wants to do it on the same day, that's fine.
Preliminary examination will be set for July 2nd, 2024, 9 a.m. before Judge Perry, both cases. Found
Thank you,
continued.
Judge. Always a pleasure. Thank you again.
Thank you. Recalls case, people versus Tadasha Pugh Powell.
Mr. Sinatra for the people.
See, I told you she'd show up. I don't know what you were talking about. I was.
Thank you. Silvana Reed, Assistant Public Defender with and on behalf of Ms. Pugh Powell. Could you state your name for the record?
Today's just people.
Thank you.
I have a plea form. Is that what?
Yes, and I have assigned rights.
All right.
Wow.
The plea form indicates that the defendant will be pleading guilty to the charge of attempted resisting and obstructing the 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding.
No contest.
I have guilty,
Right, I could be amended, that's fine.
and yes, and I have a police report I got her. And she's gonna be pleading no contest to the charge, as I've indicated.
Thank you.
Okay? All right. May I have her sworn?
Right hand. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name.
Today's Pugh Powell.
All right, you can put your hand down. Ma'am, it is this court's understanding that you're going to be pleading no contest to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yeah, it's kind of like guilty, but not guilty. I mean, it's kind of like, yeah, she explained it to me.
Yes, I explained that.
Is that what she said?
I mean, it's no contest.
I think
All right, here's what will happen, ma'am. A no contest plea. I will be reviewing the police report in this case
Mhm.
and making a determination if there are facts that suffice to make out the crime. Okay? I will take those facts as true in that police report. You understand that?
Yes.
All right. And what it means is that you're not further contesting this case.
Mhm.
Okay? You're not challenging. You understand that?
Yes.
All right. The other part that you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty.
Mhm.
You understand that?
Yes.
All right. Do you have any other questions regarding a no contest plea?
No, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability.
All right. And so, ma'am, to that charge, attempted resisting and obstructing, how do you plead?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Correct.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal a right.
Yes, Your Honor.
Are you on probation or parole?
Yes, probation.
Were you on probation at the time of this offense?
No.
Okay. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes.
of your own free will. Court has been provided Pittsfield Township Department of Public Safety for their report 24-7445. Any objections to the court reviewing that report?
No, Your Honor.
None.
Yeah, that didn't work out too well. All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied.
Defense is also satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be July 10th, 2024, 9 a.m. Or as your invite indicates, that is before me. This matter will continue. Okay?
Thank you.
Ma'am, on your way out, probation is right on the left-hand side down the hallway. Okay,
Okay.
stop in down there.
Okay.
Okay?
All right. Thank you so
Thank
much.
you.
Thank you.
Is that it for that block?
Yes.
Okay, that's it for that block. I'll come back at my 2:00 time. Court does call the case, People versus Jessica Mullins.
Well, good afternoon, Your Honor. Attorney Kevin Bassant, P71061, on behalf of Ms. Jessica Mullins, who's also present by Zoom video, Your Honor.
Yes, she is. Ms. Mullins, can you state your name, please?
Jessica Mullins.
All right, thank you. All right, what are we doing on this today?
Judge, today is the date and time scheduled for the first PCC. I just received discovery on this matter and have not had opportunity to even review it with my client. I would like to have time to do so and possibly speak with the prosecutor about a possible resolution. I'm asking if we could set this matter for a new PCC, Judge.
Any objection?
No objection. There is a community corrections violation report, and
Okay, there is.
Your Honor, have a copy of.
I do not.
Does defense counsel have a copy of her community corrections violation?
I don't have a copy of it, but I'm aware of what it may say, and I'm prepared to address it.
Okay, so it says that on June 11th, 2024, she missed her sample with community corrections, that on June 6th, 2024, she tested positive for benzodiazepine and amphetamines. It's going back before her arraignment date, probably because, oh no, sorry, there was a big gap in time. Sorry, I'll continue reading it. On May 31st, 2024, she tested positive for benzodiazepine and amphetamines. May 21, missed sample. May 16th, missed sample. May 9th, positive benzodiazepine.
Got it.
And Judge, may I
So,
address that?
I just want to make sure, I'm sorry, counsel. On the 11th, she missed or was unable to provide a sample.
It says missed sample.
Okay, got it. All right, go ahead, Counsel.
And so Judge, on that particular date and time, my client, right before she tested with community corrections, she was upfront with me. She told me that she would have it in her system. I encouraged her to still go in and test. I told her that it would more than likely come up as a violation. And we're in the process now of getting her, hopefully, into inpatient treatment at Sacred Heart. We're working with her insurance to do so. She recognizes, Judge, that she does have a drug issue, and we're trying to get her treated, Judge. So I'm hoping if the court would allow her bond to be continued, that we can get her in inpatient services as soon as possible, Judge.
All right. I'll tell you what, I was gonna give you some additional time out. Here's what I'm gonna do. She's gonna get herself into treatment, and you're working with her, counsel. I'm only gonna adjourn this out to the 27th, 2 weeks. I want to progress on the Sacred Heart, or what's she doing regarding treatment? I guess I'll put it that way.
Okay.
All right. Before I act on any violation. All right.
And Judge, let me just say this while the court is scheduling. I know the court schedules throughout the day. I just want the court to be aware that I do have a federal sentencing at 1 p.m. that afternoon, and that's probably going to be all afternoon, Judge, on the 27th.
Okay. So can you make a note of that? Can we keep track of that? So what we'll do, we'll try to get you in earlier in the day, counsel.
Okay, thank you.
If it doesn't work, then just let my staff know. We'll do what we can to.
All right, I appreciate it,
okay.
Yeah, thank you.
So probable cause June 27th, 2024. I'll set it at 9 a.m. You'll get your time block. Bond at this time will continue.
All right, thank you, Judge.
Thank you. Court calls case, People versus Stephen Walls.
Andrew Childers appearing on behalf of the people.
Michael Vincent on behalf of Mr. Walls. It's coming in from my waiting room.
I think Mr. Jackson and Mr. Pitts are back, but we'll get them in just a second. Let me just finish this one. Okay, go ahead, sir.
Your Honor, Michael Vincent on behalf of Mr. Walls. Take on the record, please. Steve Walls.
Thank you.
Your Honor, we've discussed this prior in your circuit court.
Waiver.
It's a waiver.
Yep.
Okay, thank you. All right. Mr. Walls, you're waiving your right to a preliminary examination?
Yes. Yes.
All right. And you understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
All right. And you understand you'll not have that hearing, you'll proceed to circuit court for further proceedings?
Yes.
All right. People also waive the
Yes, Your Honor. Thank you.
preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr. Vincent.
Yes, Mr. Waltz has there is a bond violation, and I wish, with the court's permission, I wish to address that.
Yes, you may, but as to the circuit court arraignment, you waive formal reading, your client stands mute.
Absolutely, Your Honor. Waives formal reading, stands mute to charge.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 18th at 1:30 before Judge Slade Thursday.
July 18th, 2024, 1:30 before Judge Slade Thursday. Yes, as to bond, Mr. Vincent.
I've talked quite a bit with Mr. Waltz. He freely admits he's addicted to amphetamines. He's struggling with his addiction. He has taken upon himself to enroll at Dawn Farms. He's been in with Dawn Farms since May 20th. It's hard to get into Dawn Farms. Fort Wells knows they're busy. So he's going to Dawn Farms, starting on 23rd. Started there on Wednesday of the 23rd. He's going to NAA now 2 times a week. I've got form of 6/9, 6/10, and 6/11 that he's gone. I wish I could say he's got a handle on it, but I think he's working on getting a handle on his addiction. He has a back pain And I've talked to him about what to do with back pain rather than taking amphetamines. He's seen a doctor and a doctor has recommended exercise, and I am a big promoter of that. And he is going to start trying to replace the pills with exercise. And he's well aware. I've shown him, that, you know, several drops that were dirty, and he's doing something about it. And I've got the documents here. We can send it to you to the court if you wish.
Anything from the people?
Nothing. Mr. Vincent and I spoke yesterday about this. He explained to me the situation with his client. Obviously, I informed him on the phone the same thing I will tell the court. I'd leave it up to the discretion of Your Honor regarding. It appears that Mr. Walls is making efforts. So
Yes.
and taking responsibility, which goes a long way.
All right. Rather than remand the defendant or revoke his bond, I'll continue his bond. Add the condition that he's continue his enrollment in Dawn Farms and attendance at the NAAA meetings. All right.
You understand what that means? You don't do it. There's a lot together.
All right. Bond will continue. All right. Thank you. Court recalls the case, People versus LB Jackson.
I think we got it.
Andrew
Judge, are we all
Childers appearing
set?
on behalf of the people?
Oh, okay, perfect. Byron Pitts, ready on behalf of Mr. LV Jackson, who appears today by.
Yeah, he's here. Mr. Jackson, can you hear us?
Yes, I can.
Okay, I've already seen you, so that's okay. Don't try to turn on the video. We're good.
Okay. Thank you.
All right. What are we doing?
Your Honor, we are not, I'm just gonna throw something out if I may. We're not interested in holding the exam. However, I did speak to the prosecutor about something that could probably be resolved in this forum. Do you wanna bind it over and resolve it in circuit court, brother counsel, or should we resolve it here? I probably have to get you something.
Mr. Pitts, what you and I spoke about was a potential of a possible drunk driving second offense, given the age of the priors. My statement to you, I believe, was if you could provide in writing something to the effect of what efforts your client is making regarding sobriety, be it AA classes, whatever.
Okay.
I think we can work this out.
Fair enough. Okay, I didn't, and I should have doubled back to you. I apologize before this. Your Honor, if I may, we're going to resolve this here. If we could, with the court's permission, I'm going to put something in writing, get some documentation to brother counsel ASAP. I'll get it in the next couple of days, and I'm hopeful we can solve this right here. Do you agree, brother counsel?
Okay.
That's fine.
All right.
Okay.
How much time, Mr. Pitts, are you going to need?
Just give me a week, Judge. Come back next week. I'll get something
Really?
to brother
You're
counsel.
going to be okay. Mr. Pitts? I don't know when the last time you've been here. I mean, I can give you a week, but I mean, I'm willing to give more time if people are resolving their cases. I don't have a problem doing that.
2 weeks.
2 weeks?
Yeah.
He's good though, because everybody else would have said, oh, 4.
I'm going to move like lightning, Judge.
Why don't I do this? Would you be available July 2nd, sir?
Second.
Yes, sir.
All right. Well,
I'm probably going to be out of town. I'm hopefully going to be out of town then, Judge.
All right. I can do the 27th then. Will that June 27th?
Perfect.
Okay. Probable cause conference, June 27th, 2024, 9 a.m. or as your invite indicates, and his bond will continue. All right.
Okay.
Thank you.
Okay. Brother counsel, could you give me your email if I may? Or put in the chat or something?
I'll send you an email.
Okay,
I'll use a bar journal. I'll send you an email.
All right.
Thank you so much. And I'll see you on the 27th. Thank you, Your Honor.
Thank you. Thank you.
Okay,
Thank you,
bye-bye.
Mr. Jackson.
Judge, love to see you on TV. You're a star.
I don't know about being a star, but yeah, I
Everybody's
was
talking
there.
about it. You're a superstar. Okay. I'll see you later.
Take
Thank you.
care.
Okay, bye-bye.
Court does call the case People versus Theory Reynolds.
Feaster, Assistant Public Defender, appearing on behalf of Mr. Theory Reynolds. Please state your name for the record.
Theory Reynolds.
Thank
Good
you.
afternoon.
Good afternoon.
Thank you, Judge. I've spoken to Mr. Sinatra and to my client, trying to get a global resolution in this case. The other case is at 14-2. Our PD there is transitioning out. and he'll be leaving. So like a 3 or 4 week adjournment.
I heard that.
Yes, yes. So I can find out who's gonna be his attorney there and try to get that part wrapped up to wrap this part up.
So my understanding, that's beginning of July, that's going to occur.
Yes, Judge.
I don't know why I know all that. Probably because go to July 11th.
Thank you, Judge.
2024, 9 a.m. or as your invite indicates, bond will continue. Thank you.
Thank you, Your Honor.
You're welcome. Sir. Court does call the case of the people versus Marche Robbins.
Maria Rosinsky on behalf of Ms. Robinson, please state your name for the record.
Marche Robertson.
Thank you.
Your Honor, we would be asking for an adjournment to talk about a possible global resolution with another case that my client has pending.
When is that other case scheduled?
They told me my next court date was on Zoom, July 9th.
It's on July 9th.
Yes.
All right, then why don't we try July 11th, 2024, 9 a.m. or as your invite indicates. Bond continue.
Thank you.
Thank you. Court calls the case, people versus Jennifer Hiller.
Judge Ganatra for the people.
Mike Getty, Assistant Public Defender on behalf of Ms. Hiller, who I believe is appearing via Zoom, Judge.
You do believe that?
Swing and a miss. Your Honor, did send her the Zoom information. I don't know if she's having technical difficulties. I'd ask the court for an adjournment.
Only for interns. Bench warrant will issue for defendant's failure to appear.
Thank you, Your Honor.
Fine, 10,000. Cash warrant will issue immediately. Court does call the case of the people versus Mario de Leon Cifuentes.
La Corte llama al caso del pueblo contra Mario León Cifuentes.
Nimish Ganatra for the people.
Ganesh Canastra a nombre del pueblo.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. DeLeon Cifuentes.
Asistente de defensor público a nombre del señor de León Cifuentes.
Okay, what are we doing today on this?
¿Qué estamos haciendo el día de hoy en este caso?
Your Honor, I've met with Mr. DeLeon Cifuentes. I'm asking for an adjournment for 3 to 4 weeks for him to review the video in this case.
Su señoría, he hablado con el señor de León Cifuentes. Estoy solicitando una postergación de 3 a 4 semanas para que él pueda revisar el video en este caso.
Additionally, I've asked Mr. Ganatra about a plea resolution and he will be looking into that.
Adicionalmente, le he solicitado al señor Ganatra una resolución con respecto a la declaración y él va a estar trabajando en eso.
Probable cause conference is adjourned to July 11th, 2024, 9 a.m. Bond continue.
La audiencia de causa probable se posterga para el 11 de julio de 2024, 9 a.m. Continúa fianza.
All right. Thank you.
Thank you, Your Honor.
Gracias. Gracias, su señoría.
Thank you, Jacqueline. Great job as usual.
Yes, sir.
Appreciate
Good
it.
day to you. Goodbye.
Calls the case, people versus Travis Bogan. Why? No, see, this is what I'm talking about. This is the intern in prison. Get us, go ahead.
Can't do it on behalf of Mr. Bogan. We were told that Mr. Bogan, CMH worker, came to pick him up today to bring him to court, and he is feeling unwell. So we are asking for a brief adjournment.
So he was on his way. Now he's not on his way.
It's a little bit of a miscommunication. I think the CMH worker was on their way to his house, but they were not on the way to court.
Talking in big words. That's what the people in Michigan do. But
Your Honor, to Mr. Bogan's credit, he did complete inpatient treatment on the 10th. He received verification of that.
Apple is thinking this is helping. No. She was doing just fine. Any response from the people? We'll make it July 11th, 2024. 9 a.m. Bond continue.
How many medicals are there?
14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Judge J. Second Simpson presiding.
May be seated. Solemnly swear from the information contained in the search warrant affidavit is true to the best knowledge and information. Please. All right. You guys do great. Thanks, Carol. Okay. Great. Thank you. Detective Erskine.
Yes, Your Honor.
Oh, there he is. How are you, sir?
Good, sir. How are you?
Very good. I've reviewed your affidavit and search warrant. If you'd please raise your right hand. Do you solemnly swear or affirm the information contained in the search warrant and affidavit is true to the best of your knowledge, information, and belief?
I do.
All right, very good. I'll sign off on this, and Ann will get these right back over to you.
Great. Thank you, Your Honor.
All right, thank you. Stay safe, please.
You as well.
Court does call the case, People versus Aaron Points. Oh. He decided to show up, do something today. Go ahead. I'm sorry. I was just shocked.
I apologize for my tardiness. I hope my intern lived up to expectation.
He did what he could. He did a fine job without you here.
I knew he could.
Yeah.
I knew Miss Apple would take care of it.
All right.
Tour show feaster.
No, it wasn't Miss Apple. It was Miss Gaines.
Oh, thank you, Miss Gaines. I appreciate it. Okay.
No, it wasn't. That team thing.
We're all a team.
Really, he was all on his own.
I knew you could do it.
Yeah, he did.
Yes.
Go ahead, sir.
Tour show feaster, assistant public defender, apparently on behalf of Mr. Aaron Points, so I understand is apparently here by Zoom.
Yes, he is. Mr. Points, can you state your name, please?
Aaron Points.
Thank you, sir.
Thank you, Judge. I've spoken to Ms. Barroso on this file. We have a good resolution pending in this case. I have to talk to Mr. Points a little bit further to make sure he understands what he has to go through to get the offer that Ms. Barroso is offering.
Okay.
Just need a week or two, and I think we'll get this fled and resolved.
All right. Probable cause conference, July 2nd, 2024, 9 a.m., or as your invite indicates. Bond will continue. Court does call the case, People versus Russell Shropshire.
Your Honor, Peyton Dewitt on behalf of Mr. Shropshire.
All right. Your name, sir?
Russell Shropshire.
Thank you. I have before me a plea form. Is that what we're doing today?
Yes, sir.
Yes. The plea form indicates that the defendant would be pleading no contest to the charge of embezzlement, 200 to 1,000, the 1-year offense. Upon his successful no contest plea to that charge, count 1 would be dismissed. There is no delayed or deferred sentencing. However, that is up to the sentencing judge. And there is an agreement of restitution of $1,967.79. That's the court's full understanding of it. Court calls the case of the People versus Craig Smith.
Good afternoon, Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Smith. Could you state your name for the record?
Craig Smith.
Your Honor, this is the first date after arraignment. I was just able to provide the discovery to Mr. Smith yesterday. We'd like to ask for an adjournment so that we can have further time to discuss that as well as continue negotiations with the prosecutor.
Probable cause conference will be adjourned without objection. July 2nd, 2024, 9 a.m. or as your invite indicates, bond continue.
Thank you.
All right. Thank you, sir. Court calls the case People versus Devon Tatum.
Kenneth Overwater, Assistant Public Defender on behalf of Mr. Tatum.
Your name, sir?
Devon Tatum.
Thank you.
Your Honor, we're asking to adjourn this matter 3 to 4 weeks. Mr. Tatum is working on coming up with some funds that will facilitate a resolution.
How much time is he going to need to do that?
About the 3 to 4 weeks. We would take more if the court would be willing.
Well, I asked the question because realistically, are you going to be able to do it in that time or you need more time?
I'm honestly not sure about how much I need to come up with. This was something that I just got assigned this attorney. My other attorney was different in the beginning, and he said that he was talking to the prosecutor about
doing it. Okay. So do we have a ballpark about what he's going to need? I just want to make sure he has time to do it. Not coming back and forth. So.
Restitution is about $7,000.
I'm not even going to ask how much time that's going to take you.
It's going to be a little bit more than 4 weeks, honestly.
Let's do this. You got to come. You're probably not looking for it all, but at least a substantial portion. So normally wouldn't do this, young man, but I'm going to do it anyway. I'm going to take you basically to the end of July, but you got to do what you got to do.
Right.
July 25th, 2024, 9 a.m. Bond continued.
Sure.
You're welcome. Court calls case People versus Socorro Thomas.
For the people.
Kenneth Overwater, Assistant Public Defender on behalf of Ms. Thomas, who should be appearing by Zoom.
Yes. Hello.
Hello. State your name.
My name is Socorro Thomas.
Thank you. All right. What are we doing?
Your Honor, I did speak to Mr. Ganatra about a possible misdemeanor resolution with this, on this matter. Spoke to Ms. Thomas. She's advised she's not interested in that resolution. I'd ask to set the matter for preliminary examination,
All discovery is complete.
to my knowledge.
People have their witnesses available the 25th. Preliminary examination will be set in person, June 25th, 2024, 9 a.m. That is before Judge Washington.
Okay.
Bond will continue. Thank you.
Thank you, Your Honor.